Hello, friends. This is attorney Andre McKinney Dorval. Guys, in this video, I want to discuss two cases that the Trump administration has already announced that it intends to appeal. And if those cases are appealed and or eventually go to the Supreme Court and the Supreme Court sides with the administration, we are definitely going to see a lot more people being arrested, detained, and placed in fast deportation. Okay, guys, the two cases I want to talk about is Sherla versus Nome and Make the Road New York versus Nome. Now, both of these two lawsuits, they challenge the use of the administration's expedited or expanded expedited removal. In the case of Sherla versus Nome, in that lawsuit, a federal district court judge has entered a temporary block on the administration's ability to place the Chin V parolees into fast or expedited deportation or expedited removal. Now, the administration has already announced its intentions to appeal that decision. The next case I want to bring to your attention is Make the Road New York versus Nome. In that case, the ACLU and other immigrant advocates have filed suit against the administration on its policy decision to expand expedited removal or fast deportation to apply to immigrants who are found anywhere within the interior. All of this as an effort to amass more people into deportation, particularly fast deportation. Now, what you need to know is that we have been seeing a pattern. What is that pattern? The administration issues or announces a policy. Immigration and other civil organizations sue the administration. A trial court enters an order that blocks the particular policy decision or whatever the administration is seeking to do. And the administration then files or makes application to the Supreme Court. And in many of these applications made to the Supreme Court has allowed the policy decision in question by the administration to go ahead and proceed, even though the lawsuit is still being litigated. What does that achieve? That achieves in between the meantime and in between time, the policy decision will amass and round up individuals, whether it's to deport them to third countries, whether it's a decision to allow TPS policy decision to be ended, whether it is to allow ICE to continue with roving raids while the lawsuit is still being fought. All of these things, when the Supreme Court allows the district court's order to be lifted, it in effect allows, while the case is still being litigated, it allows the administration to continue with what it was doing that a trial court determined was unconstitutional or violated due process or was contrary to law. Now, I'm bringing that to you because with the last Supreme Court case that we shared with you, this is something that you have got to be prepared for. Because if in either of those two scenarios, the administration is successful in being able to have these trial court orders lifted, even though the underlying case is still being litigated, what that will achieve is that the administration will be able to proceed with expanded expedited removal policy. And so that is going to be extremely important for you guys to be aware of. And so, guys, I wanted to share this quick video. I am going to do a follow-up video that discusses what should you be prepared for if we, in fact, find that these two orders that are currently in place, if they are lifted. Guys, I do thank you for watching. Please be sure to share the video and, of course, join the family and subscribe. And I will definitely see you in the next one. Bye-bye.